Other four, another breaking news as I told you, I'm speaking now, bro. I will Ghana to the four. Get to Tokonu, Yankasi, Mammy, a Chief Justice. Wait to see and Yinifia Konyaso, other four. Ever since I joined Ramani Mahama, Yinifia Konyaso, and in the discussion there, a dream that our Ghana has to see a meno Casano. Yes, see another Supreme Court judge, Cassia Pan, and I just say petition, Tintin Pan, their man is in Yinifia Konyaso. Obekai Justice Yoni Kolendi and Obi edit petition kesi edi John Dramani Mahama nakachi say enimeni yano Justice Yoni Kolendi no and ye yini mfia konjasu as Justice of the Supreme Court and now say as a judge of the Supreme Court orofo enche bia ni ye mame eye getu to konufia konjasu as a Supreme Court judge and now finish as the Chief Justice of the Republic of Ghana. Yede anoma ye say yede abo baako ekunuma mienu and at see anu ye ma mini case no kodai na enche bia ye say another Justice of the Supreme Court and as a judge of the Supreme Court IFN Justice Yoni Kolendi no yesi ono so yenyi ne fi akundwa so kese pan odofo petition kese and the idea called Bona. You see, on Lucy, if you are conjunction in India, Miss Beginning in a broke, or Ghanatube. One, my uncle, near what is answer winning and trim, or Ghanatube, Malaysia.
The area of law that would apply if this matter is to be considered at all. But barely 24 hours after petitioning the Criminal Investigations Department of the Ghana Police Service to investigate Justice Yoni Kolendi and Richard Jakpa over the alleged interference of administration of justice, Daniel Mafo Oforiata, a Chebi indigene, has escalated the matter to the presidency. Now, this time, he is asking President John Dramani Mahama to remove Justice Yoni Kolendi as a Supreme Court judge. My colleague, Dennis Poberi-Wadam Esquire, has been following this matter as it's been unfolding over the last few hours that we've been watching quite closely. And what exactly is this gentleman seeking, especially when it comes to the matter of the position of the law and if this is going to be considered, what this process will be. Yesterday, that is good to have you. Yesterday, we got to hear of Daniel Mafo Oforiata's name for the very first time because he petitioned the CID of the Ghana Police Service.
Precisely.
Now he's escalated the matter. And what is he asking for again?
Well, so that's what we are learning. That's beyond the petition that he put before the CID for some investigations to be conducted in respect of allegations he makes against his lordship, Justice Yoni Kolendi and Richard Jakpa, in respect of that conversation which we specifically detailed last night, a fallout from that particular trial, the ambulance trial last year, in which Dr. Kessler Tuforsen was standing trial with two others. We are now understanding that he also put before the presidency another petition, this time around seeking the removal of his lordship Justice Yoni Kolendi in respect of the same matter. We are only able to tell because what we gather is that from what was contained in the statement or the petition to the CID, it's basically on the same issues that have now been put in the petition again to the presidency. Mind you, this will come directly under Article 146.
With various installations currently underway, 2HB Plus development.
And as the law is, when it gets to that stage, matters are very confidential, supposed to be in camera, right from the petition to when the committee is done with its work, that if it ever progresses to that level. But the only reason we are able to understand what went into that petition is because we have already dealt with a certain leg of this matter, which is before the CID. And the understanding we get is that this petition, which we understand has been submitted to the presidency, is also predicate on the same or substantially on the same set of facts, Alfred. So that's what we are learning.
I see, but then again, if this is to be considered, and we're very mindful of the boundaries of our conversation on this as well, because as you indicated, it's early days yet. What's the process going to be?
Well, so that's also opened up another conversation which has been a very controversial one. And that has to do with the removal of the Chief Justice. Now there's an argument whether if the Chief Justice is removed as a whether the Chief Justice removed as a Chief Justice also loses the position of a Justice of the Supreme Court. Those who think that should not be the case argue that the removal process for a Chief Justice is different from the removal process of a Justice of the Supreme Court. In this case, if it ever progresses, we'll be looking at the removal process for a Justice of the Supreme Court. And that takes us again to Article 146. Except this time around, we are looking at it from the point where this would trigger a process that will have to do with the removal of a Justice of the Supreme Court and not necessarily a Chief Justice.
Chief Justice. So, then this particular provision in this article strictly applies, so that then you wouldn't have to import any other ruling in the case of Ejechum and others. This strictly applies.
Yes.
Because it's not a Chief Justice.
Exactly.
It's a Superior Court judge.
Yes.
Okay, let's get
So that's
into
why we needed to emphasize the point that the removal process for the two individuals is separate. So when you look at it, 1461 says that the Justice of the Superior Court, or in this case, let's just stick to what it is, because we know what it is.
Absolutely.
This is Justice of the Superior Court.
Perfect.
We are not dealing with chairman of regional tribunals. Shall not be removed from office except for stated misbehavior and incompetence, or on ground of inability to perform the functions of his office arising from infirmity of body and mind, that the Justice of the Superior Court of Adjudicator may only be removed in accordance with the prescribed, with the procedure specified in this article. Now, this is where it begins. This is the procedural aspect of it.
That's right.
That where the President receives a petition for the removal of a Justice of a Superior Court other than the Chief Justice, and for the removal of, he shall refer the petition to the Chief Justice.
Right.
When the President receives, he shall refer it to the Chief Justice, who shall determine whether there is a prima facie case.
So let's stay with that a bit. So in this particular the clause in this article, from what we saw in the case of the removed Chief Justice,
The Chief Justice, yes.
a 5-member committee was set up. But this time around,
But let's see, we still haven't got there yet.
let's go.
Yes, because remember, a prima facie was determined before the committee was set
Precisely.
up. So we are still at a point where it says that when the President, upon receipt of that petition,
So which has been done now.
that's what we are learning.
Right.
But of course, receipts will also be acknowledged from the presidency.
Absolutely.
So we are hoping that if indeed it's been submitted as it's been reported, then the presidency would issue a statement to that effect, if they are minded to communicate the status of how things are
It's important
shaping
to
out.
say they are not obliged to let us know.
If it progresses, they would have to.
Yes, but at this
But we have
point,
seen that in the case of the removed Chief Justice,
absolutely.
where we were informed that some petitions had been received and what the process was, and that was the beginning of the legal hurdles for that. But as we speak now, what we gather is that it has been. Except we have not heard from the presidency exactly what the status of it is.
Right.
But of course, for purposes of education, if it ever progresses, this is the procedure we are looking at.
absolutely.
From the
It's important.
president to the Chief Justice, now we have an acting Chief Justice.
Yes.
So, and then there will also be a determination of a prima facie. This time around, this prima facie is determined by the Chief Justice. Mind you, in the other procedure that I've seen in respect of the Chief Justice, it was done together with the Council of State, the President of the Council of State. In this case, it's the Chief Justice who does that. Now, after that where the Chief Justice decides that there's a prima facie case, he shall set up a committee consisting. You see that this provision is very clear as to who does what. That he, the Chief Justice, shall set up a committee consisting of 3 justices of the Superior Court. There again, you see the distinction. In the case of the Chief Justice, Chief Justice,
Yes.
there were 2 Superior Court justices. In this case, there are 3 of the Superior Court justices.
I'm very happy. I'm going to interview a legend, the strong man, Zuzu Azumanes.
They are appointed by the council, the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Right.
So clearly, there's another distinction here. In the case of the Chief Justice, you have 2 justices of the Superior Court. In fact, in that particular one, is 2 justices of the Supreme Court. This talks about 3 justices of the Superior Courts. So it could include justices from the High Court, Court of Appeal, and the Superior Court itself. So those, now that takes us back to those who argued that the processes were different. What they were essentially arguing is that if Justice Gertrude Tukono were to be removed as a justice of the Supreme Court, she ought to have gone through this process, and not one that had 2 justices of the Supreme Court, and basically, so that's the controversy is ongoing, for which the Attorney General is seeking an interpretation. That's a matter which is still pending. But just like I said, for purposes of education. Now, upon the composition of this particular committee, the committee appointed under Clause 4 of the article shall investigate the complaint and shall make its recommendations to the Chief Justice, who shall forward it to the President. There again, you see a distinction that when the committee that was looking into the matter of the Chief Justice were done, they forwarded their recommendations straight to the President. They went and met the President, handed over that envelope. In this case, they are saying that the Chief Justice will make the recommendations. No. Let's stay here. Yes. Investigate the complaint and shall make its recommendations to the Chief Justice. So the committee goes to the Chief Justice, who then forwards it to the President. Then it continues. So where the petition is for the removal of the... No, this is for the Chief Justice.
Application.
Yes. So the committee appointed under Clause 6, this is also in respect of the Chief Justice. But essentially, what it also ends in is the fact that whatever recommendations are contained in that the findings of the committee will be those that the President will be bound by. So the President shall, in each case here refers to, be it in respect of the Justice of the Superior Court or the Chief Justice, act in accordance with the recommendations of the committee. So this is how it generally looks like should this ever progress to the next stage. But like we said, this is what we are gathering based on the complaint that was made to the CID. We do know what the complaint generally is, and now we are learning that that complaint again has been put in the petition, which has been sent to the Presidency, seeking the removal of His Lordship, Justice Yoni Kolendi. And this person we're talking about is Daniel Mafo Foriata. Yes, and Daniel from Chebi. That's Daniel the man. Mafo, yes, we have his picture. That's the man in black next to Richard Jagba. Precisely. Right. I see. And it's early days yet on this. It's one that we're looking at and following quite closely, as we did indicate. If the Presidency is minded, as we saw in the case of the process as was started, where the former Chief Justice Gertrude Arabai-Saba Tukono, Felix Kwachofosu issued a press statement telling us about the receipt of the petitions. This time around, we haven't heard or seen any press statement whatsoever acknowledging receipt of this petition that is said to have been sent by this Daniel Mafo Oforiata, but it's one that we're picking up and following quite closely, the signals of this petition at the Presidency and what's going to be happening in the coming days. So stay with us here on Ghana Tonight. But there's one other issue as well that we're learning this evening, which we've also been following quite closely, and that's coming up next. It has also to do with another individual on that list that we just showed you. The General Legal Counsel has begun hearing a misconduct complaint against former Attorney General Godfrey Yeboah-Dame over the ambulance trial. We've got the latest on this. Stay with us here on Ghana Tonight. And this is as well one that has been unfolding by the hour earlier today. And this is Ghana Tonight. Listen, this is, we touched on the complaint yesterday. Then this process has started today. What do we know, Dennis? So, as part of the mini legs of this, I think this is one of the matters you can describe as looking like an octopus. Absolutely. Because it's almost everywhere. We did indicate that as part of the fallout from this ambulance trial, quite a number of things beyond the complaints to the CID, the petition to the Presidency, there was also another complaint that was made to the General Legal Counsel in respect of the former Attorney General, the Leonard Godfrey Yeboah-Dame. The complaint was to the effect that the way he went about the matter smacks of some misconduct, professional misconduct, for which this complainant wanted the General Legal Counsel to look at. That was somewhere in May. And we are now learning that the processes have kick-started. Now, mind you, the in-camera principle that applies to Article 146 proceedings also applies in respect of proceedings before the General Legal Counsel when it has to do with professional misconduct. So that also means that we are unable to get the detailed information by way of what exactly has been said, but we've been able to glean some information as to what stage of the process it is now and what essentially has been going on.
QuickBooks gives me the superpower to automate my invoices, track expenses.
So what we do know is that the former Attorney General has now given an answer to the complaint. So I usually, when the complaint is made to the General Legal Counsel, upon receipt of that, then they will make the complaint available to the respondent or the affected person to also answer to what the complaint, the issues that are raised by the complainant. So that has been done. So the former Attorney General has now given a response. In other words, he has responded to the complaint.
Okay.
That we understand or we gather that in doing so, he responded in about 6 parts. I mean, how he went about his presentation to respond in 6 parts. The first part, raising preliminary objections as to the way the complaint itself has been carried. Mind you, I had mentioned that it is supposed to be an in-camera proceeding. What it means by the same principle is that the complaint itself should not be published. But he observed that on the 22nd day of May, when this complaint was made, it was widely publicized, radio, TV, in newspapers. He thinks that it breaches the principle of the in-camera proceedings. So, to that extent, he raises the objection that it should be dismissed because already it has breached the rules of the procedure.
So it's in the public domain.
Exactly.
Okay.
Then again, he raises an issue about the capacity of the complainant himself, who claims to come under a certain provision of the Constitution. It is the view of the Attorney General, the former Attorney General, that to come under that provision without a personal injury does not clothe him with that capacity to come before the committee. So, in that respect, he wants that the committee dismisses the petition. Beyond the preliminary objections that we understand he raised, he also went into matters about jurisdiction, raising issues of prosecutorial immunity, suggests that as an Attorney General, he was not doing whatever he was doing in his personal capacity. He was carrying through his constitutional mandate. To that extent, such persons should be protected in a sense. He urges the committee not to exercise jurisdiction on that particular matter. However, he continues, as we gather, to say that if they are minded to continue, then he would give them the factual background. That is to say, his side of the story. And that's where he began to recount his side of the story, his engagement with Mr. Jakpa, together with his Lordship Justice Yoni Kolendi, and what transpired.
That's right.
Then he went on to, as it were, deny the specific allegations that have been made against him in respect of the claims of professional misconduct and all that. He concludes by saying that the complaint should be dismissed because it has no merit. So essentially, that is what we have been able to gather in respect of the matters that are before the General Legal Counsel. But that is to say, this is a process which is in motion, unlike the others that we are unable to tell exactly where they are now. In respect of this, we do know that the process is in motion.
And it's one that we're following quite closely. What is interesting is that in the case of this petition brought before the General Legal Counsel against Godfrey Eboadame, the petitioner in this case, or the person who filed this complaint, Daniel Ofoswapia.
Yes.
That's his name, Daniel Ofoswapia. And in the case of Richard Jakpa and also Yoni Kolendi, Justice Yoni Kolendi, is Daniel Mafo Oforiata. The Daniels are onto something.
That's an interesting observation.
Indeed.
I didn't really pay attention to that.
They are onto something, but we'll see how things play out.
Exactly.
But thank you.
Out of 4, when a petition Kessia, Aquacoto John Domani Mahama Nakunja so say, Eniminiano Justice.
Looking to level up your life?
Justice Yoni Kolendi no John Dramani Mahama onyi ni mfi akondwa so eniminim ya petition tintin ena Ghana for asan ede akọ eye John Dramani Mahama ne office eniminim ya onyi Justice Yoni Kolendi emfi akondwa so because ne ye bi ene ne amanema bi ene emra kwan no enko entini yesi enyi ni mfi akondwa so dofo ye ka se enyi ni mfi akondwa so na moamunim eye Godfrey Yebu Adame eye former Attorney General NPP aban former Attorney General Godfrey Adame eno ono so wako eye tese wabo ewura insem nimu eno ono so de petition kese de akose omon dismiss saa eye case na nipa ne de abase omuyi Justice Yoni Kolendi mfi akondwa so no osi omon dismiss saa complaint dodofo when a banta kesi a cost for quarter, which beginning in a bro, Ghanatube, if you send like no subscribe no my channel, my notification bell, so I send a bear. Bring a BB drop content, say a woo, when I tell watch me to mother for aha, and I bet it's a BC or Ghanatube. So, Macramina, Madame Nasi Baby.